I'm Vinny Politan. Thanks so much for joining us. Imagine being Ross Harris. You've been convicted of murdering your child, leaving him in a hot car to die a gruesome, excruciating death. You're found guilty of murder. You're sentenced to life in prison. And for every convicted felon who gets that sentence, life in prison, life without parole, they've got one thought on their mind: the appeal, a new trial, a second chance. That's all I need. And in this case, we are now 4 years from that conviction, and Ross Harris has had 2 days in virtual court attempting to convince the trial judge that she made a bunch of mistakes, or at least one big one, and as a result, he deserves a brand new trial. From where I'm sitting, folks, kind of sounds like an uphill battle, but the defense was impressive in their presentation over the course of the past couple of days, and who knows? Who knows? I mean, I doubt that the judge would overturn some of her prior rulings and say, I made a mistake and it's such an egregious mistake, you deserve a new trial. But you got to do it. You got, it's the only chance you have, right? You try to get a new trial from the judge. If this doesn't work, then you appeal it all. So let's go to CourtTV legal correspondent Chanley Painter, who's been covering this one in Cobb County for us. So give us the big picture, the big takeaway today. I mean, at the end of the day, was there, because it's different, right? It's a virtual hearing, right? So you don't necessarily have people walking in and out. But what was the takeaway when everything was done after waiting for 4 years to get back into court? What was it like?
Well, Ross Harris is going to have to wait a little bit longer for the judge to decide whether or not he will have a second chance, another trial. Today, the court concluded it's a virtual hearing. We can see Ross Harris there on the screen all day. He's appearing from prison in Macon. He has papers in front of him. He has his pen. He's taking notes. He means business. You can tell he's taking this seriously, as is his attorney, the witnesses on his behalf. And at the end of the day, after the state made some arguments, the defense responded, the judge decided to allow a little bit more time for the attorneys to file some additional briefs over some of the constitutional issues so that she could assess those. It's likely we won't have a decision until after the new year, Vinny, whether or not the judge will change her mind on any of these potential rulings she made from 2016, whether or not she agrees now that some of those may have been an error or affected the outcome of the case. So Ross Harris will remain where he is and has a few more weeks of probably hope that this judge will change her mind.
Well, I think for the defense, there's a certain level of hope in that she didn't rule immediately, because there are judges that'll do that. Right. They'll sit there, listen to everything, and say, no, you're not getting a new trial. So at least there's going to be briefs, legal arguments, constitutional arguments. I get it. So he's probably holding on to hope tonight. One of the big issues in this was the expert, Dr. Diamond, who was going to testify about how someone could forget that their child was there, how they could have a false memory of dropping their child off at daycare. And it was interesting, and I want to play this for everyone, what the senior district attorney argued today, referencing the defense's use of this issue. Let's take a listen.
Paragraph 8 of the motion to reconsider says, well, court's order is too broad and attorney work product might be given and all this sort of, So Mr. Boring's thinking, you know what? This is a trap. I'm asking for specific certain things. All I want is Dr. David Diamond's notes, whatever he has to say about what Ross Harris said that he's basing his opinion on. I don't want any work product. And lo and behold, what does Maddox Kilgore specifically hand over to the state? What he claimed yesterday was attorney work product. And Mr. Boring knew that this was a trap. He knew it in here because he went and had another assistant district attorney in Brunswick review it. Why do you think he did that, Your Honor? He did that because he knew that this was a purposeful, intentional attempt to insert reversible error into this case. And that's exactly what Mr. Kilgore did. Because at that September 16th hearing, Mr. Kilgore was told repeatedly, we don't want attorney work product. We want these specific statements.
This is a wow for me. Basically, you've got the prosecution accusing the defense of planting this as an issue as sort of plan B in case there was a conviction.
Oh yeah, she brought some passion this afternoon, Vinny, via Zoom. This prosecutor, yes, bringing some heat behind why the defense may have had this secret strategy to bring this issue up. And it sort of makes sense. So the defense is raising the ground in its motion for retrial, saying that the judge inappropriately compelled them to hand over what they call confidential work product of their expert witness, Dr. David Diamond. And because they had to hand over all of his notes that included privileged information, that gave the state an unfair advantage, and therefore they didn't call Dr. Diamond to the stand. They also say that because he wasn't on the stand, that was ineffective assistance of counsel. That's another ground they're lodging here. So all of this, but she's saying today, hey, this was purposeful. They did this on purpose to set up potential grounds for a new trial. It was really some creative arguing this afternoon.
Absolutely. Absolutely. We know prosecutors, defense attorneys, they don't always see eye to eye on things. But here, an accusation that you are doing something wrong in order to have an issue on appeal when we convict your client. Unbelievable. So let's take a listen to Mitch Durham, the attorney representing Ross Harris now, on this same issue.
The defendant's got to be allowed a chance to pursue expert testimony without being in position to reveal the theory of the defense. And here, the defense was not only put in a position to reveal the theory of their case and their ideas and their thinkings on certain strategy decisions or the weights of evidence, they gave the state a work product that did include all their thoughts, their concerns. More importantly, they gave the state this huge sword just to stab them during trial.
So am I getting this right, Chanley, that the defense, Ross Harris's team now is saying, listen, there was a request for discovery. The judge ordered it. The judge ordered we had to give everything, right? We had to give all of this information, including notes and strategy included that was written down by our expert witness, including notes and conversations with the defense team. And the prosecution is saying, no, we just wanted this. We just wanted the piece of that included Ross Harris's story, which we are entitled to, not everything. You sent us everything. We didn't even ask for everything. And now you're saying that's a reason for a new trial.
You got it exactly right, Vinny. That is what was at stake today. That's what they talked about. And that's what the state was saying. Look, we didn't want all of this information, but yet you handed it over. And in response, the witnesses today, Kilgore said, yeah, but we aren't concerned about what the state actually wants. We're concerned about what the judge ordered. And that was a broad ruling that said turn everything over. And that was wrong. That was prejudicial to our client. It affected our trial strategy. Interesting point, though, if you read the 80-page long response brief of the prosecution to the defense motion, there's a part there that actually the office of the prosecutor took extra steps because they did hand over everything. They had an outside prosecutor from Glenn County come in and go through these pages of notes and take out what that attorney thought would be work product or confidential information. So they had this extra layer or extra step of precautions before the actual prosecutors in the case looked at those documents. So they brought that up as a good point in the response to these defense allegations.
I'm wondering, did the defense know it at the time? And did that come up, during the hearing? Well, at the time we didn't know that. Well, maybe you should have known that. It's a fascinating issue. And again, I think it's a huge uphill battle. Let's get to some of the facts, though, of the case. And one of those facts involved the lunchtime visit to the car by Ross Harris. It was all on video. He goes out with his friends for lunch. They stop. He picks up some light bulbs, and then they drop him off at his car, not at the office, in the parking lot. And then they drive off, and he goes to his car and tosses those bulbs in. Brian Lumpkin, who represented Ross Harris at the original trial, one of the attorneys, testified about that.
I'm referring to the fact that the Harris residence had some light bulbs that needed replacing in a bathroom, as I recall. And Mr. Harris had bought bathroom bulbs that matched those exactly on the day of this incident. And so to the extent that we were trying to show that it wasn't some made up reason to get light bulbs just so he could go to his car and check on how things were going, as was suggested by the state and refuted by the evidence, in my opinion, there was an actual need for the bulbs, and he got them and he placed them in the car without ever getting inside the car.
Again, Chandler, sounds like a great argument in front of a jury.
Yeah, you're right. And it's important because one of the most tragic facts in this case, in my opinion, is when he goes out to his car at lunch with his baby still in the back seat, and according to him, doesn't even notice it, puts light bulbs in the passenger seat. That whole part is super tragic. But here, the defense is saying this. Now, in the context, let's put this in context. This light bulb testimony today was when the prosecution and the defense attorney was asking the witness about their strategy, the defense strategy of digging in, picking apart the credibility of law enforcement in this case, and because they wanted to call the officer who swore the affidavits for the search warrants in this case, because they believed that officer was misleading, that the officer lied in those search warrants. They wanted to put him on the witness stand. Well, the judge here limited what they could ask that witness, didn't allow them to ask about whether or not that detective lied in those search warrants. And so that's kind of the grounds for why they are talking to this person and bringing this up. But the prosecutor's like, well, you were able to get information from the witness even though you were limited in what you could ask. And that's when they said, yes, we were able to glean some incidental information about these light bulbs, which helped us in a way to give a reason to the jury why he would go out to his car at lunchtime. It wasn't something that was made up. There was a legitimate reason that he needed these light bulbs. He knew about it, and that's why he put them in the car at lunchtime.
Yeah, the easiest way to get that across to the jury would be for, I don't know, maybe Ross Harris to get up on the witness stand and explain all these things. But he didn't do that, doesn't have to, but might have helped a little bit in this case. Speaking of the lying, that was a theme, and I recall that from the trial about the accusations by the defense that you had these investigators who were lying. Well, today, Jesse Evans, the assistant district attorney, handling the case now and was part of the team initially, is also the attorney in the Ahmaud Arbery case, spoke with Michael Ayala on CourtTV earlier. Let's take a listen.
Regarding this idea that some of the investigators in this case may have lied in order to get, on an affidavit in order to get a search warrant in this case, is that something you came across, something you were concerned about? I'd like you to respond to that accusation.
Absolutely. I think it's absolutely false, and it's been exceedingly frustrating over the years to hear those false allegations against great men and women in law enforcement. These are law enforcement professionals. There was no falsehood. There was no malicious lying in these affidavits. I think the defense did their job, and they wanted to take these affidavits and parse through every single little word to see if there was any way that it could be twisted to make it sound like there was an intentional falsehood. But there's no evidence that there was any intentional falsehood by any investigators in this case.
So, again, they're not seeing eye to eye on this issue either, Chanley. So, all the evidence, the arguments, could you read anything from the judge today as she was listening to everything?
I really couldn't. She seems a bit terse and stern sometimes, especially towards the defense. I mean, they are asking her to overrule her own decisions. That's tough, right? And for her to naturally, I would be a little defensive if you didn't think I made the right decision here or there. But as a judge, she has to be fair and impartial. And I have no doubt that she will be. She's allowing them more time to brief issues, and she's taking time to consider it, like you said earlier. So, no, I didn't glean anything from watching her today.
All right. Sometimes judges are obvious and sometimes they're not as obvious. And I think Judge Staley fits in the latter category.